There is now, and what we're going to talk about, is a corporate license to kill. So this is the story of how the civil justice system became impotent over the last 10, 15 years against the power of big corporations. And basically what we're going to talk about is three different changes in the law. Massive, the effect has been massive on how corporations conduct business these days. And it's happened in three different areas. Punitive damages, and we're going to go back to a 2003 U.S. Supreme Court case, and there have been cases since then, especially in 2008. Mandatory arbitration, a seminal case in 2011, and campaign finance, especially the financing of electing judges, because a lot of state courts, judges are elected. So if corporations can overwhelmingly finance one judge over another, that has a massive effect on the law. So these three areas, changes in punitive damages, mandatory arbitration, campaign finance, and these changes from the United States Supreme Court, not disputed or argued over politically, almost never in the news, almost never covered at all. Even when those cases were covered, what happened over the next 5, 10 years in corporate boardrooms is never covered. And that's why I say this story is not well known. So, Bob's going to start with punitive damages.
It was a completely different world when I graduated law school in 1981 as far as our ability to have an impact on the corporate world and their conduct and the way they treated the public and their customers and consumers. It's completely changed now. And as John said, what we want to talk about today are these decisions from the United States Supreme Court, which I hope that you will understand. I hope that you will understand by the end of this talk how your rights, the people in this room, your rights have been taken away. And the rights of these multinational corporations have now been engrafted into the United States Constitution by the Supreme Court of the United States to give these entities, these monolithic entities, constitutional rights at the same time that they're taking away your constitutional rights. And that's what we're going to try and talk about today. The first thing is punitive damages. We used to control the conduct. I say we lawyers who would represent our clients and you indirectly, to make cars safer, to make pharmaceutical products safer, to make food products safer. We used to be able to control their conduct through punitive damages because they wouldn't want to be exposed to large damages. That has now changed. We can't do that. I've seen what these companies do. And when I see what they do sometimes, it takes my breath away. It really does. And you may see it on the news every now and then or in a movie, right? A fictional recharacter of what happened. But I know what happened because I've seen these. These are my clients. These are my people. I've seen the documents. I've seen the smoking gun documents. In the corporate world, well, let's say in the human world, as John said, if he were to go out and kill somebody, he could fire a real gun, right? And then that's where the phrase smoking gun came from. If you can find the person that's holding the smoking gun, you got pretty good proof of who did the murder, right? But that's the way it is for real human beings. But with corporations are fictitious entities. They're created on paper, right? They can't go out and actually pull a trigger on a gun. But they do have smoking guns, and they're usually in the form of internal company memorandums, right? Internal secret company documents. Summer vacation, great family. Look at the joy in their face, okay? So, as they were on their way back to the condo, they came to a toll booth on the Virginia Turnpike, and they stopped to wait to go through the toll booth to pay the toll. And all of a sudden, they felt a little tap, a little bump from behind. And that's all it was. Everybody, all the witnesses that saw this, the people in the car, everyone that was involved said it was just a little bump, a little tap. They felt like someone had thrown a softball and hit the back of the station wagon. And then this happened.
Oh, geez, look at her.
Oh my God! Oh my God, that's all the skin? Oh my God! Oh my God, that poor girl!
There was a passerby who had a video camera. I mean, obviously these days there would probably be 100 iPhone videos. of this, and this is just an excerpt, a short excerpt of the video that was taken there at the toll gates. Horrific, horrific accident from a bump from behind. So how does something like that happen? We did some investigation. And on the right there, on your left, I guess, you can see this is a picture of the back of the station wagon. And what we saw was that that fuel tank, which is painted yellow, hangs down right below the bumper, right in the back of the vehicle, completely and totally unprotected. Now, if you were to go on the showroom floor and buy this vehicle, of course, that would be spray painted black, right? And it would just blend in with the whole bottom of the vehicle, and you'd never notice it as you were walking around. You never think to ask about it. But, so the jury could see, and so you all can see, we painted the tank a bright yellow. And so when you see it like that, you get the impression, right away you should get the impression, whoa, that doesn't look very safe, right? That doesn't look very safe. So we send out written questions, they're known as interrogatories. We send out written questions to these companies, and this question was simple. Did you ever consider protecting this fuel tank? Did you ever consider putting a tub or a shield or something around it to protect it? And so we went back and forth. We went back and forth. 5, 6 hearings, they wouldn't answer the question. Blah, blah, blah. They'd answer all these questions, but they would never say, did they ever consider putting a shield around the fuel tank? They wouldn't answer it. And finally, the judge said, I'm going to strike your pleadings. I'm going to sanction you guys if you don't answer the question. These were long 2, 3-page answers, but they never answered, did they consider putting a shield around the fuel tank? Well, just as the judge was about to strike their pleadings, my brilliant young associate at the time, who's now my law partner at my law firm, was a very young guy, but a very bright guy, and he had taken off in an airplane and started flying around the country to other lawyers that had been involved in other cases, other fire cases against General Motors, and other places to see if we could find this information on our own. And sure enough, he found it in Alabama, if I'm not mistaken. Alabama. We found the document on the right. Oh, by the way, at the very end, when the judge said, I'm going to sanction you if you don't give a direct answer, did you ever consider putting a shield around the fuel tank? They lied, and they said, no, we never considered it. At that point, I already knew, because it was like a day earlier, he had flown back in with the drawings, and I was just waiting to see if they would tell the truth or not, and of course they didn't. They said, no, we never considered it. But John had just flown in from Alabama where he had found the design drawings. This is the actual design drawings for that vehicle, for a plastic tub. It says encapsulating the steel tank, goes right around the tub to protect it from impact. So yeah, they thought about it. And yeah, they did design drawings for it. So they obviously considered it, but they didn't put it on the shield, on the fuel tank. Why not? Turns out, we found out, and this was later on down the road, that General Motors had done a value analysis just like Ford had. You've all heard of the Ford Pinto case where Ford had done a similar thing. General Motors, another corporation, friendly General Motors, had done the same exact thing. One of their engineers in the advanced design department did a calculation where he determined how much it would cost the company to pay the claims for these people that would burn alive in these accidents. How many of them are we going to have on average per year? How much is it going to cost us for each family that we got to pay to settle the lawsuit? And he came up with a number, and he said, well, how much is it going to cost us to protect these cars so that these fires don't happen? The number happened to be $2. He says, his analysis indicates that to General Motors it would be worth approximately $2.20 per new model auto to prevent a fuel-fed fire in all accidents. So for $2.20, and this is an actual memo. This kind of stuff as a lawyer, when you get it, you're like, really? Really? $2.20? But if you multiply it across the product line, it adds up to a lot of money. And the question is, well, how much are you going to have to pay in lawsuits versus how much is it going to cost you to make these cars safe? So we had this memo. So you would think, well, that's it. They're guilty as charged, right? They're obviously guilty. They have this memo. They got the drawings that they lied about. But that's not the end of the story. But you would think that's the end of the story, right? You've got the money. You got them cold. They did the analysis. But no. What we found out was that Ivy, this memo had come out about 15 years. It actually was another hurried production in California in a case. And they accidentally, General Motors lawyers gave it to a lawyer in California. 15 years before our case, okay? And so once it came out, all these other lawyers across the country, Texas, Pennsylvania, New Hampshire, South Carolina, all these other lawyers where people were burning alive in these cars wanted to take Ivy's deposition because of the memo. And so Ivy, he had to show up. Obviously, he had some information that was relevant to the cases, right? But he testified in every one of those cases. I don't know why I wrote it. I don't remember. I just wrote it on my own. I know that. No one in management ever asked me to do this, and nobody ever saw it. That's what he testified to, okay? For 15 years. And so, those lawyers, like the lawyer in Virginia, couldn't get it into evidence. The judge would say, what's the relevance? Ivy did it on his own. General Motors didn't even know about it. How can you hold it against the company? And so for 15 years, in these cases where these children and families members burned alive in these cars, they were turned away by juries. General Motors not responsible, because they never got to see this analysis. It was kept out of evidence. But we found that there might be another document out there that was related to that memo. And so we came back and we asked them to produce it, and again, it was hearing after hearing. They wouldn't produce. And again, the judge, just like the fuel tank tub, the judge said, if you don't answer it, produce the document one way or the other, either you got it or you don't, I'm striking your pleadings, I'm going to sanction you. And so again, under hurry, John and I were in Detroit. Under hurry circumstances, they had the documents delivered, and that was the result. Okay, that's not him. And then that document, which I'm not allowed to talk about, neither is John to this day, we read, and we saw the truth. We saw the truth about his 15 years of testimony across the United States. This was a 6-month trial, by the way. This trial lasted for 6 months right here in Hollywood, Florida. 6-month trial, and in the middle of the trial, at this point, Judge Franza, who was the judge, knew what was at stake. He knew what the case was about. And so, we got him. And what did we learn out? This is what we learned. These are excerpts from the document. Said that this was done. This is an attorney who interviewed Ivy about, and this document said that Ivy characterized the nature of his analysis, submitted to Muddy, who was his supervisor, who was in charge of Oldsmobile, who was in charge of the station wagon that was the one that burned in this case. But his analysis was submitted to them and others to assist them in trying to figure out how much they could spend on fuel systems. He agreed that they did not like the sound of the study, and he admitted that they were very cautious with distribution of the copies due to the nature of the subject matter. The lawyer concluded at the end of this memo, he said, obviously Ivy is not an individual whom we would ever, in any conceivable situation, want to be identified to the plaintiffs in a post-collision fuel-fed fire case, and the documents he generated are undoubtedly some of the potentially most harmful and most damaging were they ever to be produced. So, I mean, he was right? And so that's why they fought tooth and nail to keep all this stuff secret. This is what corporations do. That's what I'm trying to tell you. That's the whole point of this, okay? And they are getting constitutional rights and yours are being taken away. That's the real point of this topic, of this talk today. But what I'm trying to show you is what they do, because you would never believe that people would actually do this, but they do. They do. I've seen it in automotive cases. I've seen it in pharmaceutical cases. I've seen it in tobacco cases. Company after company putting your lives, your children's lives on the balance sheet. They do it. It's not made up. It's not pretend. So let me turn this over to John for just a second. He's going to talk about what's happening with your right to a jury trial.
But let me see if I can give you the context. This can't happen anymore, right? The takeaway from this, to me, is people don't, this is a post-collision fuel-fed fire. People don't burn alive anymore in post-collision fuel-fed fires. This case and others made them change the design of those vehicles, and I'm going to show you how we know that in a second. SUVs don't roll over just because you steer them in a certain way on the highway anymore. There was litigation for 2 decades on what some people call it the rollover wars. The short version of that is SUVs were insanely lucrative vehicles, and there was a rush to market once the first ones started selling so well. Companies would take a pickup truck like the Ford Ranger, slap a roof on it, put some seats in the back, and sell them at crazy markups for cheap vehicles. And they were making so much money, it didn't matter that they were paying a lot in lawsuits. Okay, so how did the law change how vehicles were designed? Car designs have changed because of lawsuits. In a Nissan rollover case that Bob and I did, at a deposition, a former Nissan employee told us that there is a document inside Nissan that analyzed how lawsuits changed the design of vehicles. We wanted that, obviously. We requested. They said it didn't exist. That is almost always the end of the story. You go into court, you say, Judge, the judge says, what do you want me to do? What can he do? They said it doesn't exist. Well, in this case, that happened. It was Judge Jeffrey Streifeld who he was a relatively tough. A lot of lawyers were afraid of him. They sent a young lawyer there, which was a mistake. They thought it was just going to be, he was going to say it doesn't exist. They didn't know I was going to say, I know it exists. A Nissan employee told me after a deposition. That young lawyer didn't know how to respond to it. The judge pressed him. He was afraid of the judge, and he said, that document isn't authentic. That kind of admits, it does admit there is a document that exists. And as soon as Judge Streifeld heard it, he started cross-examining that lawyer, who got more and more flustered until he took out a folder and started looking at something. And the judge said, is that the document? He said, yes. The judge took it from him. We were in chambers at a table. He took it from him and gave it to me and said, I'm ordering it produced. Now, you don't understand how crazy that is. The normal course of it would have been they deny it, and that's the end. Even if we find out that it exists and the judge orders it produced, then there's an appellate court that many times steps in and says, no, it's a trade secret or some privilege or something else. And then, even if it's ordered produced, they offer $50 million, and that document never sees the light of day. But he just handed it to me. And that young lawyer, he didn't go back to his office and tell anyone. The reason we know that is because when we got to trial and we put it in evidence, the Nissan trial lawyers were shocked that we had. But anyway, that's too long a story just to tell you that Nissan did an analysis of all the other car companies and found out that just like them, there's 3 reasons why car designs are changed in regard to safety. A large number of lawsuits about a given part, cost of defense now increases so it's now, look, it's all about the math. What's cost more, fixing a defect or paying the victims? The cost of defense, if there's so many lawsuits, and that's what happened in the rollover, can be high enough that they have to change the design. 2, it's found defective by a jury and the verdict was publicized. Without that, there's no financial bottom line effect because the publicity can affect sales. Or 3, there's a high settlement cost or big verdicts. Okay, so that's why they change designs. There's more in that document that's very interesting. But anyway, now you know the math, how they decide whether the change design, you know why people don't burn alive from post-collision fuel-fed fires anymore, why sport utility vehicles don't roll over just from a steering input on a flat, level, dry road. That can't happen anymore because of Supreme Court decisions, starting in 2003. So I want you to imagine General Motors making $1 billion in profit every month. $1 billion in profit, not revenue, every month. Okay, and I want you to think about the testimony in the McGee case. The best fix to that problem costs $30. Sorry, it only costs them $200,000 on average per lawsuit. That adds up to $2, when you do the math, $2.20 per car. That's all it's worth to them. Hopefully our lawsuit changed that math. It did, ours and others, and that's why they fixed the problem. 33 million cars at issue. $30, it's almost $1 billion that they saved by not fixing that problem. So imagine a company that makes $1 billion in profit a month that saves $1 billion by not fixing a defect, even though hundreds of people are going to die. If each one of those people have a case, $2, $3 million per death, compensatory damages like we talked about, the Supreme Court is now saying the punitive damages are limited. It doesn't matter how much money they make, right? That's why this is rich corporations who have this license. And it doesn't matter how much money they saved by the fraud or by not fixing the product. You have to base the punishment, the fine, the only punishment available, on how much the compensatory damages are. And normally it should be 1-to-1. So if it's a $2 million verdict for the family, another $2 million, that's it. 100 people, $200 million. But they saved $1 billion. Now you can't change the math. That's the change in the law on punitive damages, and that's why lawsuits aren't going to change and make cars safer anymore. The second area that we were going to talk about is mandatory arbitration. Starting in 2011, there have been massive changes in how the law in arbitration. But this is how it used to work with financial fraud. So 5 years ago, the lawsuit concluded against banks, because what banks would do, imagine someone who lives paycheck to paycheck. And the biggest bill they have, say, is rent, $1,000. And they wait till the last minute to give that rent check because their direct deposit on their paycheck or their paycheck, they're depositing it, and they're hoping the money comes in before that rent check goes out. But it doesn't, so they bounce a check, one check, $40 fee. The banks, all the major banks, would take that check and move it up, hold all the last 10 checks, take that big check and put it 10 checks earlier, so now they could charge $40 times 10. Imagine that. It's just pure theft. And all the major banks were doing it. The courts stopped them. No, you can't do that. In class action lawsuits against the banks, they made this to the tune of billions of dollars they were stealing over many years. Okay, the courts stopped them. That can't happen today. Okay? So in response to that, almost every major bank has put into their account agreements an arbitration clause. You all have them, okay, but now you can't sue your bank. You have to go to an arbitrator. Well, what's so wrong with that? First of all, let me say, the law assumes this fiction, in order to give this corporate right to big corporations to force you to arbitration, to give up the right that's actually written in the United States Constitution, which says you, as a person, we the people in the Constitution, you have the right to go to a jury of your peers to have civil disputes decided. But no, corporations now, according to these cases, have a greater right to force you to arbitration. The law assumes a fiction that you had a choice. You can't get a cell phone if you won't sign an arbitration agreement. I tried to buy a car 2 years ago because car dealers, used car dealers, they love to take advantage of people. They'd love not to get sued. I couldn't find a single dealer that would sell me a car. I said, I'm here to buy, just cross that out. They wouldn't do it, not a single one. So that you can't get services in this country today if you're not willing to sign an arbitration agreement. Well, what's so bad about that? Consumers win 20% of the time on average. They get 12 cents on the dollar in arbitration. Corporations receive 98 cents on every dollar claimed and almost always win. Verizon, Time Warner, Sprint, with 200 million customers over 5 years, so over 1 billion customer years, faced only 75 arbitrations. Why? Okay, so you have to understand, they're writing the arbitration agreements, they pick the arbitrators. So you're going to lose. Even worse, you can't bring a class action. Okay, so who's going to spend $50,000, $100,000 to get $300 back in an arbitration context? Because you still got to hire a lawyer. The worst thing about this is the United States Constitution specifically says in black and white, in easy-to-read language that anyone can understand, that a human being, a citizen of this country, has the right to trial by jury in a civil dispute. And yet, it's gone with the fiction, because these corporate rights, somewhere in the Constitution that I can't find, it says that you can only award punitive damages with a single-digit multiplier of the compensatory. That takes precedence. And it's not in there. You can't find it. It's been read in there. The right of corporations to have arbitration agreements. It's not in there, but somehow it's been read in there, and not only read in there, but superior to your right as a person to have a jury trial. So campaign finance just talks, listen, if corporations get to pour money in and elect the judges who make decisions on their cases, which is specifically happening, Mississippi example, obviously that affects what happens in those cases. So this is the end, and I'm going to specifically talk about what you said. Let me start with, to me, the future looks bleak. I don't see how any of this is going to be reversed. Initially, these new corporate rights were granted by deeply divided courts, 5-4 decisions. But now, just in 2017, recently, it was 7-1. So it's gone from a deeply divided court to almost unanimous. So I'm very pessimistic that courts can solve this. However, I would point out Thurgood Marshall from the 1930s obviously faced a bleak situation, and he used to say he believed in the civil justice system, and it took decades, but there was a change. There's only one good way to handle that bunch, he'd say, take them to court. And so that's what me and Bob are going to continue to do. But I don't think this can be changed in the court in the end. Just like the civil rights movement, it's got to be changed because people think differently about this. Look, there's a well-funded propaganda effort, and I'm using that word specifically, well-funded intentional propaganda effort by big companies because there's massive amounts of money at stake to make people confuse fraudulent cases, which is a real problem. But what does it have to do with someone who's harmed by the intentional wrongdoing of a company? To confuse ridiculous lawsuits, to use them to discredit punitive damages, which are only for intentional or egregious wrongdoing, not fraudulent or ridiculous lawsuits. And the ambulance chaser advertising, which I hate, which is horrible, when they shove the billboards with the people like, I got money with a smile. I'll tell you, not one of my clients was ever happy at the end of the lawsuit, no matter how much money they got. I can't stand those people smiling. But the civil justice system is the only thing standing between us and the corporations doing whatever they want. So, let me end with a quick story. There is a lawyer, this will be under a minute. There is a lawyer, she was a law clerk in our law firm, and now she's a lawyer, not at our law firm. But she knows more than most people about what we're talking about. And she was driving on the highway on 595 West. An alligator, believe it or not, ran out. She hit the alligator, and the car flipped. And she was telling me that story, and it flipped like 6 times. It's a very serious crash, highway speeds. And at the end of that story, she said, that car saved my life. I was thinking, because I served in those rollover wars, I saw why the design, and just real quick about that, part of the rollover litigation was whether the roofs used to crush. And that, again, the engineering, there was no reason for that. They just had to make them a little stronger. When the roofs crush, someone gets paralyzed or dies. That roof didn't crush in her car. And I saw how the designs changed. I saw the time it took. I saw why it changed. And so what I wanted to say to her was, yeah, the car saved your life, but lawyers, judges, juries, and righteous lawsuits saved your life. The civil justice system saved her life, or at least stopped her from being paralyzed. And until people understand that, not just lawyers, but people everywhere understand that, this is never going to change. It's not going to be changed in the courtroom.
What can we do as consumers to fix this situation, if anything?
That's a really good question. That's a really good question. I think, my opinion is it's going to take a constitutional amendment, another constitutional amendment to the United States Constitution to limit money, the corporate money that can go into political races, because I think that as long as they have unfettered access to our politicians and therefore the judges, that you're going to have a hard time changing the law and bringing it back to a fair balance between everyday people and these multinational corporations. To amend the United States Constitution is a huge undertaking, and as you've probably seen, there's entities out there trying to get it going right now. But I think that's a very important place to start, and we need a leader in this country that really wants to give the rights back to the people. And so far, we haven't seen that in any of our recent presidents, any of them, Democrat or Republican.
And I would add, too, you could start with, in your own mind, not confusing the real problems we have with the civil justice system with other things that let big companies get away with intentionally hurting people. Those are two different issues. And when you hear people confusing them, because you'll hear it all the time, there's a discussion about frivolous lawsuits that turns into a discussion about caps somehow on righteous lawsuits. Keep that in mind. Understand the distinction and talk about it with people.